Law in the state of Louisiana is based on a more diverse set of sources than the laws of the other 49 states. Private law, that is, substantive law between private sector parties, principally contracts and torts, has a civil law character, based on French and Spanish codes and ultimately Roman law, with some common law influences. Louisiana's criminal law largely rests on English common law. Louisiana's administrative law is generally similar to the administrative law of the U.S. federal government and other U.S. states. Louisiana's procedural law is generally in line with that of other U.S. states, which in turn is generally based on the U.S. federal rules of civil procedure. History. The first Louisiana Civil Code Digest of 1808 was written in French and subsequently translated into English. For many years, legal practitioners in the state made great effort to ensure that both versions agreed. Despite those efforts, some clauses were found only in one version or the other, due to modern legislative enactments which repeal and reenact Louisiana's Civil Code articles as any other collection of statutes. The differences between the original French and the English translation are now primarily of historical interest. Despite popular belief, it is incorrect to say that the Louisiana Civil Code is, or derives from, the Napoleonic Code. Rather, the two law codes stem from common sources. Although the developing Napoleonic Code strongly influenced Louisiana law, it was not enacted until 1804, 1 year after the Louisiana Purchase. The main source of Louisiana jurisprudence may in fact be Spanish. Currently, the Louisiana Civil Code consists of 3,556 individual code articles. Effective differences. Great differences exist between Louisiana and civil law and common law found in all other American states. While many differences have been bridged due to the strong influence of common law, the civilian tradition is still deeply rooted in Louisiana private law and in some parts of criminal law. One often cited distinction is that while common law courts are bound by stare decisis and tend to rule based on precedents, judges in Louisiana rule based on their own interpretation of the law. This distinction is not absolute, though. Civil law has its own respect for established precedent, the doctrine of jurisprudence constant. But the Louisiana Supreme Court notes the principal difference between the two legal doctrines. A single court decision can provide sufficient foundation for stare decisis. However, a series of adjudicate cases, all in accord, form the basis for jurisprudence constant. Moreover, Louisiana courts of appeals have explicitly noted that jurisprudence constant is merely a secondary source of law, which cannot be authoritative and does not rise to the level of stare decisis. Property, contractual, business entities structure, much of civil procedure, and family law are still strongly influenced by traditional Roman legal thinking. Louisiana law retains terms and concepts unique in American law. Usufruct, forced heirship, reddition, and lesian beyond moiety are a few examples. Due to the civil law tradition, Louisiana's constitution does not contain a right to a trial by jury in civil cases, although this right is contained in the Louisiana Revised Statutes. Additionally, appellate courts have a much broader discretion to review findings of fact by juries in civil cases. Also, damages are apportioned differently from in common law jurisdictions. Specific performance is almost always available, and juries may hear cases that would be considered equitable in other jurisdictions. In commercial law, the 49 other states have completely adopted the Uniform Commercial Code, thereby standardizing the rules of commercial transactions. Louisiana enacted most provisions of the UCC, except for Articles 2 and 2A, which are inconsistent with civil law traditions governing the sale and lease of goods. However, several articles regarding the incorporation of terms into a contract have been adopted into the Civil Code. Louisiana also refers to the major subdivisions of the UCC as chapters, instead of articles. since the term articles is used in that state to refer to provisions of the Louisiana Civil Code. Legal careers are also molded by the differences. Legal education, the bar exam, and standards of legal practice in Louisiana are significantly different from other states. For example, the Louisiana bar exam is the longest of any state, at 21.5 hours. The multi-state bar examination is not administered in Louisiana.